Hello, everybody.
Mr. Watts, are you going to need a breakout room with your client? She is present by Zoom.
I don't believe so, Your Honor.
Okay, thank you. Judge, I think we're ready to rock and roll.
Okay, thank you, Chris. We'll go on the Zoom record at this point. And the case is entitled State of Kansas versus Jesse Kathy Adams, 24 CR 437. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Ms. Adams, appears in person and by court-appointed counsel Jim Watts. This matter does regularly come back before the court this date on the defendant's motion to suppress, filed with the court February 20, 2025, scheduled for hearing today at this time. And Ms. Norris, is state ready to proceed?
Yes, Your Honor.
And Mr. Watts?
Yes, Your Honor. Would ask witnesses be sequestered, please.
Court grants the motion to sequester witnesses. The court does find that Detective Tom Akers is to be the first witness.
Judge, I think I have them all.
Thank you, Chris. And Ms. Norris, you may call your first witness.
Your Honor, state calls Detective Tom Akers.
Sir, if you'd raise your right hand, I'll administer an oath. You do solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
And Detective Akers, please speak slowly and distinctly so we may take a good record. Please proceed with direct examination, Ms. Norris.
Thank you, Your Honor. Please state your name and occupation for the record.
My name is Thomas Akers. I'm a detective with the Butler County Sheriff's Office.
And how long have you been in law enforcement?
I've been with the Sheriff's Office for 14 years now.
And how long as a detective?
As a detective for the last 4.
And were you working your capacity as a law enforcement officer with the Sheriff's Department on January 25th of 2024?
Yes, I was.
And did you have cause to get involved in a case that was kind of, I guess, moving through the county involving Jesse Adams?
Yes, I was.
Okay. And can you explain, I guess, your initial involvement?
When the case was first put out, it was a kind of a rolling incident. Multiple deputies and other agencies were requested to assist to try to locate and to stop this vehicle. It was identified as a large silver Infiniti SUV. This vehicle was located by the Augusta Department of Public Safety. It was actually at the Casey's on 7th Avenue. I responded to Casey's in Augusta to assist in whatever capacity that I could.
Okay. And so you go to Casey's in Augusta. What do you find when you get there?
By the time that I had arrived, there was 3 occupants identified in the vehicle. They had already been removed. I don't recall the exact members of the Department of Public Safety that were there, but I know that the individuals in the vehicle were suspect of the ongoing incident. We had known at this point individuals in that vehicle had brandished a firearm and had threatened other individuals. This was the reason why they were requested to be detained. When I got to the vehicle, I noticed the driver door is open, vehicles parked facing southbound at the gas stalls. The 3 occupants in the vehicle, of which include Miss Adams, they were at the back of the vehicle between the islands and the store, just kind of not free to leave at that point.
Okay. And but they were not in handcuffs?
They were not.
And had they been patted down for weapons?
I don't know.
Okay. So then what happened? So and you said there's somebody from Augusta there, but you're not necessarily sure who it was.
Yes, there was a handful of officers there. I know at one point Chief Ackerman shows up. I know I did majority of my conversing with members of that department with Chief Ackerman, pretty much. Essentially, we had determined that, we had a need to check this vehicle. In addition to that, we requested Deputy Chip Weber to run a canine open air sniff on the vehicle, which was done.
Okay, so you get there, you're talking to Chief Ackerman. Are there any other officers there at this point?
Members from the sheriff's office include Sergeant Camp Schroeder, former Deputy Patrick Bruce. I know Chief Ackerman was there. Another officer from Augusta was there. I don't believe Officer Dean had been there at that time. I think she was called to the scene after the fact.
Okay, so and then you say that Deputy Weber came in with his drug canine.
That's correct.
Okay, about how long after you got there did Deputy Weber arrive?
Pretty soon.
Okay, so like less than 5 minutes.
That's fair.
Okay, and then what happened?
So Deputy Weber ran his canine Lego. She alerted positive indication, which was reported to us by Deputy Weber. At that point, we conducted a search of the vehicle.
Okay, and what did you find?
The vehicle was pretty cluttered. It's a very large SUV. From the floor to the ceiling, it was pretty checked with items. As we were searching through the vehicle, actually, former Deputy Bruce explained to me that he had found some mushrooms in the back seat, which were photographed, which I photographed later, not necessarily in the back seat. But at that point, we had learned from speaking with members of the Augusta Department of Public Safety that Mr. Mogul, one of the individuals in the vehicle, was removed from the driver's seat. A Mr. Napier was pulled from the front passenger seat, and Miss Adams was found in the back seat. Based on this, we understood that, number one, the first two were already identified in the aggravated assault by the victims of this case. At this point, in finding suspected controlled substances in the backseat, we had further reason to detain and or arrest Miss Adams.
Okay, and while you're doing the search for the drugs, were you able to locate any firearm?
We actually found a packing, like the plastic packing for a mock Beretta PX4 Storm, but it was a BB gun. We found that. I don't exactly recall where we found it, but I know that it was, I can't say. I don't exactly remember where it was found, but it was found within the vehicle.
Okay. And then you said you found mushrooms in the back seat near where Miss Adams had been sitting.
Correct.
Okay. So what did you do at this point?
At this point, we have to make a decision to clear the scene. Casey's a busy store, and we have 3 individuals in custody and being suspected of other issues. We have a need to interview them.
Okay, let's back up. The 3 individuals at this point, have they been arrested? Have they been cuffed? Have they been, more thoroughly searched? Before, you said they were just milling around outside the vehicle, not free to leave the gas station while you did some investigation.
Correct. So to clarify or to draw the line of distinction, this was a fluid moving element. As soon as we had found what we believe psilocybin mushrooms in the back seat, at this point we have cause to continue on a criminal investigation against Adams for possession of controlled substances. That hadn't developed until after we found the mushrooms and had learned that she was in the back seat. So up to this point, they had not been placed in handcuffs. They had not been told they were under arrest. However, we were detaining them so that way we could continue this investigation into the aggravated assault. In fruition of having discovered the mushrooms and in the totality of circumstances from the victim report that we already had, we did arrest Miss Adams and Mr. Mogul and Mr. Napier with the intent to have them transported to the Butler County Sheriff's Office for formal questioning.
Okay. So, did you actually, I guess, put the cuffs on Miss Adams, or did someone else do it at your request?
Yes, I did not put handcuffs on anyone. That being said, I was coordinating with Chief Ackerman for the need of a pat search or a search of Miss Adams. Due to the fact that she's cross-gender, we wanted a female, and a female was available, Officer Dean in specific, so that way we could get a search done on her, so that way she could be safely transported.
Okay. So were you present when Officer Dean, who is a female officer with the Augusta Department of Safety?
I was not present during the search, but I did make that request to Chief Ackerman. I requested a female officer, not necessarily specifically Officer Dean. He made the arrangements for Officer Dean to be called to the scene. Then a search was conducted. She was then subsequently put in handcuffs. This was not done in front of me. I don't know necessarily who did, but I can honestly say that it was at my behest.
Okay. So, and so Miss Dean arrives, or sorry, Officer Dean arrives. Is she involved in any way in this investigation?
No, she was called to the scene. I would expect that she had no prior knowledge of necessarily the things that developed, other than what was put on the radio if she happened to be listening. I didn't converse with her in detail about the investigation or what was discovered. If you would, there would be like 3 sets of groups working together toward a common goal. One, not at Casey's, actively searching for a spot where we had already quickly assumed that the gun had been thrown from the vehicle, which we later had confirmatory statements that it had. Officers were out searching there. Then we had officers standing by with the 3 individuals removed from the vehicle. And then I was a part of the group that was searching the vehicle.
Okay. So once the search is complete, a female officer from Augusta comes, does a thorough search of Miss Adams, and then she's basically put in handcuffs. And was anything found on Miss Adams when this search was done, when she was basically being arrested?
It was explained to me by, I can't recall exactly who told me. I want to say it was Chief Ackerman who told me that during the search of Miss Adams, Officer Dean had discovered some controlled substances, or at least a pipe concealed on her person, in addition to 2 plastic magazines for a BB gun. These items were seized as evidence.
Okay. And was there a bag of crystal substance also located on her person?
Yes.
And did you send, or did someone send those items for testing?
I did not. I'm not familiar with any testing. I know that Detective Sperry ended up taking lead on the investigation.
And that was at a later time?
Correct.
Okay.
I apologize. I have no clue if that was actually sent off for testing.
That's all right. That's not really the issue in the motion to suppress today anyway. But Detective Akers, I don't think I have any further questions for you, but Mr. Watts may have some follow-up. Thank you.
Thank you.
Thank you, Ms. Norris. And cross-examination, Mr. Watts.
How you doing this morning, Detective?
Not too bad.
Okay, I want to start where you arrive at the Casey's in Augusta.
Okay.
For my purposes in this hearing, I don't care what happened out on the road. You arrive at the Augusta Casey's. Who's already there?
I met specifically with Sergeant Camp Schroeder and Deputy Bruce, and I don't remember. There was a male officer from Augusta I think Chief Ackerman showed up pretty quickly after me.
Yeah.
But I don't exactly remember who all from Augusta was there. If I remember correctly, there were 2 officers from Augusta, but I do remember Sergeant Camp Schroeder, Deputy Bruce, and myself being there.
Okay. Now, when you arrive, the vehicle that you're looking for, this silver SUV, is it parked at a gas pump? Is it in front of the store? Where is it?
It's parked at a gas pump. It's
Okay.
facing southbound, and it was about in the middle of the row of the islands.
And the persons that were in it, I take it when you arrived, they're already out of the car.
This is correct.
Okay. And you identified the 3 persons that were in the car identified to you, correct?
Yes, that information was given to me.
Okay. And as you understand it, there are 2 males in the front and a female in the back seat. You don't know which side.
That's correct.
Okay. Now, at the time you arrive, are the 3 persons that have been removed from the vehicle, they are detained, correct?
Yes.
Okay. And I want to make sure I understand that distinction. At that point, an investigation is still ongoing. They have not yet been placed in custody, but they are detained for investigation. Would that be fair?
That is fair.
Okay. And given the nature of this particular investigation, given that there were reports, remember back on the highway, of some guns being displayed, these 3, I assume, would almost certainly have been patted down for weapons very quickly.
If I had been there to remove the individuals, I would have removed them and patted them for weapons.
But they were already out, so it's fair to presume they've already been patted for weapons. Would that be fair?
Yes.
And there are other law enforcement officers there. I cannot imagine, given the circumstances here, that they wouldn't do that. Would that be fair?
That's fair.
Okay. And a pat for weapons, an external pat for weapons, just so we're clear, we're talking about not reaching into pockets, but basically an external pat down for something that is hard, that can be identified as a weapon.
Yes,
Correct?
pat search should be over the clothes, brief, full contact, and then unless you can articulate a weapon or something else very specifically, then we're not going into pockets.
Yeah, and given these circumstances, completely understandable. All right. So when you arrived, those 3 persons are standing outside. My client obviously is the female, Ms. Adams.
Yes,
She obviously was patted down as well, correct? At the time you were there, does Ms. Dean arrive to do a more thorough search of her?
yes. This is it. I wouldn't be familiar with any kind of pat search that was conducted of Miss Adams prior to me being there.
Okay.
The only pat search I'm familiar with is the one that I requested.
Okay. Is that the one Ms. Dean did?
Yes,
Okay. So you requested, and then you made the request for Ms. Dean to get there. All
through
right.
Ackerman.
Correct. Is that right?
That is correct, through Chief Ackerman.
Okay. What Ms. Dean does is not a pat search. Would that be fair?
I don't know. I didn't witness it.
You didn't witness it. If Ms. Dean testified that what she did was considerably more intrusive than a pat search, would that be inconsistent with what you observed?
I didn't necessarily observe, well, I did not witness the pat search. However, my intent was for her to be searched,
Okay.
intrusive search,
An intrusive search.
as in like, we're going to make sure that she is removed from her, all of her possessions.
Okay. Was she placed under arrest?
At that time, under the pretenses that she was found in connection to, well, found in the proximity of controlled substances, yes.
Okay. So she's placed under arrest. Is that prior to or after Ms. Dean's search?
It would have been before. That being said, Miss Adams was never instructed that she was under arrest. It was a decision that I made, that it was expressed and explained to other officers on scene. This is the circumstances we had found controlled substance near her, but we did not discuss that with Miss Adams.
Okay. Well,
Correct.
let's talk about those controlled substances. We were talking about mushrooms, correct?
Correct.
Okay. They're found in the back seat. Where in
Correct.
the back seat?
I don't exactly remember. I know that it was in the back seat. And I know that Deputy Bruce had discovered exactly where they were at. This information was reported to me.
Okay. You don't know if it's left side, right side. You don't know if it's under something or over something or sitting on top or under a pile of clothes, or you have no idea. Fair?
Correct.
Okay.
I know that it was in the back seat.
Okay. Who owned the car?
I'm sorry, can you restate that?
Who owned the car?
Oh, I have no idea.
Okay. And let's put it this way, another person was in control of the car, as in basically the driver.
Sure, yes,
That would have been Mogul.
yes,
you know.
Mr. Peter Mogul.
Okay. Okay. All right. So your position is that Ms. Dean, or excuse me, Ms. Adams is, although you don't communicate it with her, is being placed under arrest for, as you put it, proximity to controlled substances.
Within her immediate control, correct?
Do you know of any law that says it is illegal to have controlled substances in your proximity?
No,
No. It's illegal to possess them, of course, but
Correct.
proximity doesn't necessarily mean possession, and possession doesn't necessarily mean proximity. Be fair?
in an argument, yes,
In an argument. I assume you're right now at your office there at the sheriff's department.
correct,
Okay? You have a TV at home?
yes.
You're in possession of it?
It's at home, yes, and it's mine.
Okay? But you're not in proximity to it?
No,
Okay? If I walk over to your office and set down a bag of mushrooms on your desk, are you in possession of them?
very soon will be. Yeah, I understand it. And no, in that particular sense, no.
Okay. Okay. I don't think I have any other questions of you. Thank you, sir.
Thank you.
Any redirect, Ms. Norris?
Your Honor, just a quick follow-up. You mentioned earlier in your testimony that the vehicle was very full of stuff.
Yes,
So was there basically only one spot for the defendant to actually sit in the back seat?
that
Was
is,
it that kind of full?
yes. It was very clear due to the vacancy of items where Miss Adams would have been sitting. And as I recall, would have been about the middle of the back seat.
Okay, so basically everywhere else is full of stuff.
That's correct.
And were the sherms found? I mean, basically, did they go through all of the stuff that was stacked in the back seat, or would they have had to have been found in the open area, or I guess more open area where Miss Adams was sitting?
I do not specifically recall where they were found. That being said, they were found pretty early into the search that was reported to me by Deputy Bruce. We hadn't reached through the level of items yet. We were still in the process of that. So from my understanding, it was brought to my attention very early on during the search. It would have had to have been found, the best way I can describe it, before the bottom. It wasn't buried within the items.
Okay, so the big stack of things in the vehicle in the back seat, it was found before you actually went through that big stack of items.
Correct.
Okay. All right. Thank you. I don't think I have anything further.
Thank you.
Thank you, Ms. Norris. Any recross, Mr. Watts?
No, Your Honor, thank you.
Any reason why the witness may not be excused, Ms. Norris?
No, Your Honor.
Mr. Watts?
I don't believe so, Your Honor. Thank you.
And Detective Akers, you're free to go or stay as you wish. The court does need to take just a very brief 2 to 3 minute recess, and then we'll be back on the record.
While we're doing this break, Jesse, can you hear me? Okay, can't you unmute there for a moment, real quick?
Jesse, if you tap your screen of your cell phone, it should bring up your camera and your microphone.
I see it. Sorry, it took me a
There we
minute to
are.
find it.
There we are.
Hi.
I just want to ask you, while the judge is taking a short break, do you want to talk a little bit? Do you think we need to talk a little bit here?
Yeah.
Okay, Chris, can you put us in a brief breakout?
I sure can, Mr. Watts. Miss Adams, if you'll hit that join button, please. Okay, Judge, Mr.
Yep.
Watts. Mr. Watts is in a breakout room with his client.
Thank you, Chris.
Judge, I'm not too sure we didn't, oh no, Mr. Watts is still there.
I just believe he's not in his chair.
Yeah. I just lost him for a minute.
Okay.
Your Honor, do you have access to the court file or have the court file?
I do.
Okay. I was just going to be referencing a filing when we get back on the record. So,
Okay. Thank
Thank
you, Amber. All right. I think we have all parties back to go ahead and continue on with the
Okay,
motion to suppress. So the court at this time will go back on the record, and the record may reflect the presence of counsel previously appearing along with the defendant. And Ms. Norris, you may call your next witness.
Your Honor, this state initially would ask that the court take judicial notice of the notice of intent filed on 24 CR 437 on February 6th, which basically includes two different lab reports. One that specifically addresses the mushrooms and then the rest basically speaks to several meth items.
Thank you, Ms. Norris. And Mr. Watts, any objection to the court taking judicial notice of the notice of intent referred to by Ms. Norris, filed of record February 6th, 2025?
no, Your Honor, although for purposes of today's hearing, I don't know that they're particularly relevant, but no objection.
Thank you, Mr. Watts. Court does take judicial notice of the same. And Ms. Norris, you may call your next witness.
Your Honor, the state calls Officer Raquel Dean.
Officer Raquel Dean, you've been called as the next witness for the state. And Miss, if you'd raise your right hand, I'll administer an oath. You do solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, nothing but the truth, so help you God.
I do, Your Honor.
Please proceed with your testimony. Please speak slowly and distinctly so that we're able to take a good record. And we'll begin with direct examination by Ms. Norris.
State your name and occupation for the record.
Raquel Dean, I'm an officer with the Augusta Department of Public Safety.
And on January 25th of 2024, were you working in your capacity as a law enforcement officer?
Yes,
And did you get a call to go to Casey's that day?
I did.
And can you just explain briefly how that came to you?
I was asked by my chief, Chief Ackerman, to come and search a female that they had detained, and that's what I left to go do.
Okay, so you get to Casey's. What do you do at that point?
I get out, I meet with Chief Ackerman and also Sergeant Strobe to find the female that I'm supposed to, excuse me, search. And they led me over to her, and that's when I began my search.
Okay, and at this point, when you're doing the search, is she in handcuffs?
I do not 100% remember if she was or not. I believe she was, because I remember her arm moving to try and block a certain area that I distinctly remember searching and where I had found something.
Okay, so where did anyone else witness the search that you did?
Yes, Sergeant Strobe and Chief Ackerman was also there.
Okay, and so you're doing this there in the parking lot at Casey's?
Correct.
Okay, and you're doing a search on Miss Adams, but prior to this, you're not involved in this investigation.
Correct.
Okay, so you're just there as a female officer because it's a female detainee.
Correct.
Okay, and what, if anything, did you find on her person during this search?
In her coat pocket, I had found a small piece of plastic tubing that I had taken out. I think it was purple and probably an inch or two long, and there was a second piece of clear plastic tubing that I had also removed from that same pocket. When I continued my search, she was deflecting, I believe, on her left side, to kind of shove me away from searching that area. I continued. I told her to stop interfering with my search, and I eventually had pulled out I believe, a sandwich size plastic baggie that had contained a white powdery substance in it. And that was it, located in her left, like, leg and abdomen fold area.
Okay. And anything else?
That was all that I had gotten off of her person.
And did you actually have her empty your pockets, or were you actually physically searching all of her pockets?
Yes.
Okay, so you didn't have her empty the pockets, like say, like empty them on the hood. You actually physically went in and emptied the pockets yourself.
Yes, I did.
Okay. And you didn't find anything that was related to like a gun or firearm?
No, I did not.
Okay. So basically some plastic tubing, small plastic tubing, and then a baggie with a white substance in it is what you found.
Correct.
And then once you were done with the search, what did you do?
I stayed there just to have eyes on her, make sure she wouldn't leave until custody was transferred over to a deputy with the Butler County Sheriff's Office.
Okay. And what did you do with the items that you found on her?
I gave them to, I believe, Sergeant Strobe, the tubing, or I'm sorry, the baggie, and then the tubing I had given to Deputy Bruce.
Okay. So you handed those items over to other law enforcement officers.
Correct.
Thank you. I don't think I have anything further.
Thank you, Ms. Norris. And cross-examination for the defense, Mr. Watts.
Thank you, Your Honor. Ms. Dean, do you remember giving testimony on February 10 of this year?
I do.
Okay. Now, you remember at that hearing, you gave testimony that when you arrived, it was your understanding that she had already been basically done external pat down for weapons. Is that correct?
That is correct.
Okay. And in fact, we talked a little bit at that time about you're on the fire side rather than the law enforcement side, correct?
That is the division that I am assigned to. However, I still upkeep a full-time law enforcement certificate.
Oh, I understand that. I guess costs change their people, and I get that. Okay.
Yep.
So what you were called to do, or what you did, maybe more accurately, is a much more intrusive search as a search incident to arrest.
Correct.
Okay. Do you remember testifying on February 10th that, and I wrote it down in my notes, at that point, your words, she was placed under arrest following the search?
Yeah.
That was your testimony on February 10, correct?
Correct.
Is that still your testimony?
Yes.
In fact, your testimony is she was placed under arrest as a result of the items found during the search, correct?
Yes.
Okay. I have no other questions. Thank you.
Thank you, Mr. Watts. Any further direct examination, Ms. Norris?
Your Honor, just briefly, you did not do any investigation. This case was not even Augusta Department of Safety's, was it?
Are you asking me?
Correct.
The crime that initially had occurred, from my understanding, was in the county. It did not originally occur in the city of Augusta.
Okay, so this was not Augusta Department of Safety's case.
No,
Okay, and you didn't do any investigation,
I did not.
and you basically did a search on the defendant, Miss Adams, at the request of your chief.
Correct.
Okay, and when you did the search, would there be, do you guys wear PRDs? Would you be wearing a PRD since you were in fire?
I was not, since I was in fire.
Okay, nothing further, Your Honor. Thank you.
And any further cross-examination, Mr. Watts?
Just one thing, Judge, and I'll be as brief as I can. You write a narrative in this case?
I did.
Okay. Do you happen to have it with you?
I do.
Okay. Before I ask you to look at it, who is Sergeant Strobe?
Sergeant Danny Strobe with the Department of Safety,
With which department?
with the Augusta Department of Safety.
Okay.
Excuse me.
I'm gonna direct you to your narrative dated, looked like it's written Tuesday, February 6th. Do you have that in front of you?
I do.
Okay. And I look at the narrative, and you do narratives as much as possible in a chronological order. Would that be correct?
Yes.
Okay. Now you weren't wearing a body cam, personal device, correct?
That's correct.
Did you have a chance to review any other officers' personal devices before you did your narrative?
I did not.
Okay. Only reason I ask that is because it's pretty common for officers to review their narratives or review their cameras as they're recording, as they're writing narratives for obvious reasons. Your third paragraph of your narrative speaks to the details of the search, does it not?
It does.
Okay. Talk about in the groin area, something tucked between the left leg and vagina and so forth.
Yes.
Okay. What's the very first sentence of the very next paragraph?
Sergeant Strobe then placed Jesse under arrest.
Okay. Got nothing else. Thank you.
Thank you, Mr. Watts. Anything further, Ms. Norris?
Your Honor.
Any reason why Officer Dean may not be excused from the proceedings? Ms. Norris?
No, Your Honor.
Mr. Watts?
No, sir. Thank you.
And Officer Dean, you're free to go or stay as you wish.
Thank you.
Have a good day.
You too.
And state may call its next witness.
No further witnesses, Your Honor.
Thank you, Ms. Norris. Any witnesses, Mr. Watts?
Not at this hearing, Your Honor, but to be perfectly blunt, I'm surprised by that because the Deputy Bruce was subpoenaed for this hearing. And that subpoena, because I checked just before the hearing, was returned and served in this matter. Detective Akers repeatedly referred to what Deputy Bruce in particular told him. Deputy Bruce is not here. Now, that would not have been hearsay, assuming Deputy Bruce had been present. But Deputy Bruce is not present, surprisingly enough.
And Your Honor, the defense did not object to Detective Akers basically giving his testimony as he saw fit. So
Defense did not object because the state had that witness subpoenaed and returned, but did not put on.
Your Honor, again, defense did not object at the time of the testimony. So that's why the state was resting, because everything got in that the state was interested in getting in.
Well,
So
Judge, at this point, I'm going to move to strike any testimony from Detective Akers that's based on what Deputy Bruce told him.
and again, Your Honor, he did not object as hearsay.
Okay, thank you, Ms. Norris. Thank you, Mr. Watts. And court finds that there was no objection made by the defense at the time of testimony of Detective Akers. So subsequently, the court does overrule and deny the same.
Fair enough.
And the
Your Honor.
court does note that Deputy Bruce
Yes, sir.
was subpoenaed and the return of that subpoena was filed with the court. Thank you, Mr. Watts.
Judge, no witnesses at this hearing at this stage would obviously like to be heard. The burden, of course, rests with the state here.
And argument by the state, Ms. Norris.
Your Honor, we would ask that the court find that the defendant's motion to suppress should be denied. Law enforcement had dogs run around the vehicle. They alerted mushrooms, or what appeared to be illegal mushrooms, were found where the defendant had been sitting in the vehicle, which was she was a passenger in, but like I said, it was found where she had been sitting, and it was noted that there was so much stuff in the vehicle that there would have been only, basically one spot where she could have been sitting, and it was that area that they were found almost immediately. She was then searched, incident to arrest by an Augusta Department of Safety female officer, and then transported to the sheriff's office for interviews. Your Honor, it appears that the search was incident to arrest for drugs, and we would ask the court deny defendant's motion to suppress based on the legitimate search incident to arrest.
Thank you, Ms. Norris and Mr. Watts.
Thank you, Your Honor. Well, that's a nice theory, Your Honor, but it doesn't bear with the facts that we've heard here today. This case turns on some really fundamental, important things about the order in which officers do things. Ms. Adams is subjected to 2 searches. One of them is very quick, and it's as soon as she removed from the car, the Deputy Akers says he didn't observe it, but he cannot imagine under any circumstances that a pat-down search would not have been done, particularly given the circumstances of this case with the report of firearms. Although it turns out they weren't actual firearms, that doesn't make any difference. Firearms being displayed from the vehicle. Ms. Adams, and no one disputes that Ms. Adams was given a pat-down search following her removal from the rest of it, the order matters a lot. And the testimony that matters is not from Detective Akers, who wasn't there. He didn't observe the search. He didn't observe the pat down. He didn't observe them being removed from the car. He didn't observe much of anything. He got this second or third hand from other officers who were there. Interestingly enough, the psilocybin that the state relies on as the basis for her arrest, the state didn't charge her with. They charged the owner and driver of the vehicle, if I remember correctly, with the psilocybin. They did not charge Ms. Adams. So they didn't think it was attributable to her enough to charge her, but now they're going to rely on that arrest. Again, Detective Akers did not see and did not observe. What we have, in fact, is testimony from the person who conducted the search firsthand. Officer Dean arrives to do what she describes as a much more intrusive search. It is a search incident to arrest. It is a search into pockets. It is a search inside the clothing. It is a search, as she describes it, inside the folds of the stomach between the leg and the vagina. It's a search incident to arrest. The problem is that there's no arrest yet. And she makes that incredibly clear in her very own statement, and it could not be any clearer. She makes the written narrative, as she testified, that Sergeant Strobey, by the way, an Augusta officer there at the scene, not secondhand, firsthand, Sergeant Strobey then placed Jesse under arrest. And by the testimony of Officer Dean, who conducted the arrest, placed her under arrest as a result because of the items found during the search. What the state seeks to do is to search the defendant, find the items, and then justify that very search as a search incident to arrest for the arrest that has not been made yet. You don't get to do that. You don't get to arrest a person or search a person thoroughly, a search incident to arrest, then arrest them, and then claim that that search is a search incident to arrest. Now, Detective Akers says this is a fluid situation. I'm sure it is. There are a lot of agencies. The problem that Detective Akers has is he's that second agency. He's not there at the time this search is conducted. The persons who are there, the person who was there, the person who was there most directly makes it very clear. There was a intrusive search conducted, and then the defendant arrested as a result of the items found during that intrusive search. And that is what you absolutely cannot do. That intrusive search requires, when you're talking about a person, in almost every circumstance, a search incident to arrest. You can't do a search incident to arrest and then make the arrest. Thank you, Your Honor.
Your Honor, if I might be heard just briefly in rebuttal.
Yes.
Your Honor, Mr. Watts has apparently forgotten already what Detective Akers has already said. Detective Akers was on scene almost from the very beginning. He wasn't there when they were taken out of the vehicle, but he was the one basically watching the dog search the vehicle, watching the vehicle be searched, and then making the decision to have a law enforcement officer who is female to come do the search incident to arrest, because they were arresting Miss Adams. He was the one making all of those decisions. He makes it sound like Officer Dean, who is on fire and not involved in this whatsoever, other than to do a search incident to arrest because this defendant is female. That is her only involvement. She's not there. She doesn't know. That's what she said. That's what she wrote in her report, but it's not Augusta's case. They're there for backup only. The decisions are being made by Detective Akers, and he mentioned it more than once while he was on the stand, that he was the one that made the decision that she should be arrested. He was the one that everybody was bringing information to. He was the detective on the scene that was calling the shots. So I would disagree. State's position still stands. The motion to suppress should be denied. And again, I think Mr. Watts not clear on what Detective Akers was saying. I'm not sure if he wasn't listening or what, but either way, Your Honor, we would ask that the court deny the motion to suppress.
Thank you, Ms. Norris.
And I would also note for the court, Your Honor, we did not charge Mr. Mogul with the psilocybin mushrooms possession. He was charged with a lot of things, but that was not one of them.
Court makes inquiry to counsel because I don't have available the read back today, but it's the court's understanding that Detective Akers testified that he placed the defendant under arrest before the intrusive search, but the defendant was never advised that she was under arrest.
That
Is that
as I recall, Your Honor.
Is that counsel's understanding, Ms. Norris
Yes, Your Honor.
and Mr. Watts?
Judge, I have that recollection. I'm not sure how you do that, but okay.
Court makes inquiry to counsel. I'm not familiar with how someone is placed under arrest without knowledge being communicated to the defendant of the arrest. I'm unaware of any case law to that effect.
Your Honor, I think
Is
Detective Akers.
effective. Yeah.
Your Honor, I think Detective Akers was basically stating, or at least that it was kind of my understanding, that he was not discussing what was going to be happening with Miss Adams. He had made the decision to arrest her and called in for the search. He just wasn't necessarily telling her this information, but he was making those decisions with other officers as they were proceeding through this whole case. I don't really think it's necessary that he has to tell her for it to be a legitimate arrest based on the search they did of the vehicle and them finding the contraband. I mean, whether he tells her or not, she's, under arrest and she's being searched. Incident to same. And if she's actually in handcuffs, it's probably fairly obvious.
I would be very open to any case law that counsel may be aware of that's relevant to this issue.
Judge, I don't know of any case law of this issue. I guess the problem I have with the state's position is if I carry the state's position to its logical conclusion that the decision to arrest is an arrest. And the decision to arrest, while an officer may make a decision to arrest someone, that doesn't mean it's effectuated. If I were an officer, I could sit here in the office and decide to arrest Miss Norris. That doesn't mean she's under arrest. We have to do something in order to place her under arrest that's going to, either by words or actions.
And Your Honor, I think there are plenty of actions that they took thereafter.
Thank you, Amber. Please let me finish.
Sorry, I thought you were.
That's going to have to communicate to her in some way that she's been placed under arrest. It might be words, it might be actions. There's got to be something that's relevant here. The interesting thing about this is Officer Dean, who doesn't testify to this in February, by the way, but testifies to it here, that she may have been in handcuffs while she's placed under arrest. I have done dozens of cases, as I'm sure Ms. Norris has, where persons are placed in handcuffs as detained at a scene, but officers are very quick to point out that that's done for personal safety reasons and not because they're under arrest. So the admission or the placing a person in handcuffs by themselves doesn't define arrest either. The legal standard as arrest is placing a person in a confinement where they are not free to leave isn't really very helpful either, because you could say the same thing about detention. And we know there's a distinction between detention, which Ms. Adams is clearly being detained, and full-blown arrest based on probable cause. It would be my position. Again, I don't know of any cases that speak to this sort of remote arrest, where a decision is made to arrest someone, and the argument is made that that decision to arrest is itself an arrest, that there doesn't have to be some action taken or statement made to clearly communicate that there has been arrest. I don't know of any case where an arrest is done by mere decision. It's much the same as custody. An officer can claim that a person's in custody on a pursuit, for example, but until such time as they actually catch the person and detain them in some way, they are not in custody. So I don't know of any case law that says that the decision to arrest is by itself the arrest.
Thank you, Mr. Watts. And further argument, Ms. Norris.
Well, Your Honor, I believe Detective Akers noted that the three individuals out of the vehicle, including the defendant, were detained, but that they were basically being watched. They were not in handcuffs, and they were wandering or, sort of, meandering there in the parking lot where all of this is happening. So it didn't appear that they were already in handcuffs. And then the decision to arrest, there are actions taken thereafter. The law enforcement calls in a female officer to do a search incident to that arrest. That is accomplished. Other items are found, but I think because of the Augusta officer basically doing the sheriff's department a solid, Mr. Watts is calling whatever she says as actually what's happening, when she admits she's on the fire side. She was just there. It was not an investigation. It was not even Augusta's case. It was the sheriff's department's case. So it was the sheriff's department who was making the calls. And so even if the sheriff's deputy did not say specifically, you are under arrest, the actions taken by the law enforcement officers lead you, he said, either you have to say it or you have to take an action. Well, there were actions taken, several of them thereafter, after the decision was to arrest her based on what they found in her seat in the SUV after the search of the vehicle, based on a dog hit by the sheriff's office. And I don't know of any case law one way or the other, Judge, without, any further research.
I will note just in passing, Your Honor, and this is outside the record, and I understand that. After reading Deputy Bruce's narrative, I understand entirely why the state did not call him.
All right. All right. The court subsequently has had an opportunity to consider the testimony that was taken here today. The court does find that there was action taken by law enforcement. Court subsequently does adopt the argument of the state here too, and subsequently does overrule and deny the defendant's motion to suppress.
Would the court consider withholding that final decision until Deputy Bruce can actually be brought in to testify? Perhaps a motion to
Well,
reconsider.
I think, Miss Norris, I don't know what Deputy Bruce is going to testify to, but I think it is an unusual circumstance where an individual is subpoenaed and the return is made, and then that individual is not available for testimony.
Your Honor, there were multiple witnesses we subpoenaed that we did not call.
Okay. Well, that is true. All right. The court will stand with the decision that's been rendered here today.
Will the court consider a motion to reconsider with Deputy Bruce's testimony?
I think that would be appropriate. Yes, I think that's a proper forum to put it in. Let me see. Let me go off the record at this point to get a time for a motion to reconsider with Deputy Bruce being present.
And if I inquire with Amber, I think Deputy Bruce is actually now former Deputy Bruce. Is that correct?
That is correct. He's no longer with the sheriff's office.
Let me do this. We're off the record. Amber, can you call over to the sheriff and see if we've got everybody here today. See if we might be able to locate where he is.
I doubt the sheriff's office would be much help with that. He's no longer with them. I have his contact information, but
Okay,
like I said, I was not concerned about it. Defense did not object. So I just blazed right through. And like I said, there were multiple other witnesses that were subpoenaed that I didn't call either. So
that is correct.
I have his address and we have contact information, but I don't know that I can necessarily get him here in the next, 5 minutes.
I
And
understand.
I have a full day this afternoon. So as do you.
I understand you do. So we'll just need to go through scheduling for a motion to reconsider with Deputy Bruce present. It's Mr. Watts's motion to reconsider with Deputy Bruce being called to testify. I think it's appropriate for the defense to have the burden to subpoena in Deputy Bruce. Can you give that information to Mr. Watts at this point in time so he has that available for subpoena purposes?
Your Honor, he
Yeah,
can
John.
get it from the subpoena that's already on the record.
That's
in the record
right now. Yeah.
You got it? Okay.
I have a address for Deputy Bruce on the subpoena. He has, and he was served by tack and mail at that address in this case.
Okay. And what address do you have?
And Your Honor, I'd prefer that we
I-
not put that on the record.
Yeah, I'd prefer we not on a public.
It's okay. You want to go off of Zoom? I mean, you want to go off of YouTube and communicate?
And Your Honor, he has the proper address, the one that we
I
have
have.
that's on our
Okay.
subpoena. He has that.
That's all I need.
don't want to put that out on Zoom.
Yeah.
That we will not put that out. We've got the proper address for a motion to reconsider with Deputy Bruce being subpoenaed in by the defense. And Chris, I was gonna suggest a motion date and time that we might have available, criminal motion. And Chris, can you hear me?
Judge, would
Yep.
April 28th at maybe 1:30? I think we're gonna have a jury trial the next day, but we could do that. That would probably be about the soonest we could do it.
Yeah, I don't know if that's too soon or if that's appropriate. Today's
Or do you want to
the
go a little further out?
17th, probably a little bit further out.
Okay. Maybe May 12th at 9:30. That's the day before another jury trial, but we could fit it in there.
Judge,
Okay,
it looks like when I'm in front of Judge Webster that morning.
Okay.
Well,
all morning.
I think I take that back because I don't think that's correct. I think that case has been converted to a felony and I don't think it's in front of Judge Webster at all anymore. Neil Beeben, I don't believe that's a felony matter at all. Give me just a moment, Your Honor. Let me grab that file.
Yeah,
Yeah, it actually was a felony. Now it's a misdemeanor.
Oh, it's the other way around.
Yeah, so you are in
Okay.
front of Judge Webster,
Okay.
likely.
Yeah, I'm in front of Judge Webster then.
okay. And she would be on a docket basis most all morning.
Oh, yes, that's
Yes.
true.
Do you think we could do,
And I'm gonna have to do it early, Judge, because I'm in front of Judge Ricky at 10. So
10?
that morning's not a good one.
Okay, our next date, Chris?
May 19th, we have about that whole day.
Well, I know, I'm in front of Judge Crum at 10 o'clock on, looks like 1, 2, 3 cases. Docket, looks probably a prelim docket. Although I haven't pulled those files.
It's
Judge
sentencing
Ricky
docket, Jim.
Sentencings and Judge Ricky at 1:15, and then of course Judge Crum in the afternoon for the 2:30s.
Yes, for the PHC. Okay.
I would say, Chris, if you could avoid Mondays, they're not very good for
Yeah.
Yeah.
either one of us.
Okay, hey guys, is Wednesday, well, probably that will be somebody's evidentiary hearing day though, too.
I can't keep track of what days, which judge has got a Wednesday on.
Yeah.
There's
But
probably a
yes,
schedule out
generally
there
Wednesdays
somewhere.
are prelim days.
They're
for most folks. So
prelims.
if you can do Tuesday or Thursday, maybe.
Well, let's see what we can do. Right now, well, that won't. Okay, May 27th, we're open about all day. And May 29th, both of those were open about all day.
The 29 works better for me, 27's jury trials, and there's also other stuff already set.
Sure.
So maybe in the afternoon on the 29th.
Yeah, that works.
How about 1:30?
Okay, so May 29 at 1:30. I think we've got everyone that is agreeable to that. So court will go back on the record, and the record may reflect the presence of counsel previously appearing along with the defendant, Miss Adams. The court will schedule the defendant's motion for reconsideration for Thursday, May 20, 2025 at 1:30. And this is a motion for reconsideration of the motion to suppress with Mr. Watts responsible for the subpoenaing of former Deputy Bruce.
And Your Honor, that's the 29th or the
May
20th?
29th,
May 9th,
20
1:30.
May 29, 2025 at 1:30. I'm sorry if I misspoke.
And Your Honor, then we would remove the pretrial and jury trial that are set April 25 and April 29 officially.
Any objection, Mr. Watts?
No, Your Honor.
And I don't know about speedy trial on this. Is there any objection to this being counted against the defense?
Judge, it would have to be a motion to suppress is always counted against the defense. So yes, it would count against the defense.
Okay. So 1:30, May 29, 2025. This is the motion to reconsider.
Okay, I did remove those from our schedule for the PTC plea and the jury trial for this month.
Thank you, Chris.
Just to double check, Ms. Adams, did you get those dates? The April 25 and 29 dates are removed. You do not have to be here for those. However, we will have a hearing much like this one on May 29 at 1:30.
And Miss Adams, you are on mute.
Yes, I got that.
Okay.
Okay, and Miss Adams, the court does retain you on the bond that you've previously posted. I do order you to stay in contact and communication with Mr. Watts and your bail bondsman. Keep them advised all times, current address, telephone number, place of employment. And the court does order you to be back present here by Zoom on May 29, 2025 at 1:30 on the motion to reconsider with the defense being responsible for the subpoena in of former Deputy Bruce.
Okay,
Anything
thank you.
further, Miss? Thank you, ma'am. Anything further, Miss Norris?
No, Your Honor.
And Mr. Watts?
No, sir. Thank you.
There being nothing further to come before the court is in recess.
Okay.
Everyone
now,
have a good day.
I do still have 2 witnesses in the waiting room. Do you want me to bring them in?
Deputy Bruce wouldn't happen to be one of them, would they?
Nope.
And
Mr.
Chris, we
Warren?
don't need to bring them in. If they have any questions, they know how to get a hold of me.
Okay, I'll just close out of the hearing.
Thank you.
Thank you.
Be safe, be well, sleep sweet, and much love.